Beloved Creator of all that is, we are the people on the land and soil on Oregon. We have a right to be free and self-determined, and with both of those come great responsibility. It's a responsibility that may be as much, if not more arduous than being compliant to limited living and following what is determined for us by others. But we choose that responsibility and its challenges. Mistakes may be made, yet in discernment, in valuing one's quality of life and cooperation with equally valuing the lives of others, help comes, cooperation ensues, and generosity is contagious. So with this realization, we call in our divine beloved Creator to guide us in making the best, most righteous decisions and right action. As above, so below. We are here in this abundant garden Creator has entrusted to us. We have been given the miracle of birthing children of God's children. We, as complex social beings, are here to sing and dance and experience the joy of communion, commingling, abundance, and above all, love. Let it be so, and so it is.
Thank you, Charlie.
A brief in support of the claim that bar-controlled courts are unconstitutional private bar courts. 1. Introduction. The people of Oregon assert that all courts requiring judges to be members of the Oregon Bar Association, a private association, operate as unconstitutional private bar courts, usurping judicial power vested in the people by the Oregon Constitution. This brief demonstrates that no constitutional provision authorizes bar control of the judiciary, that statutory mandates such as ORS 2.020, 2.540, and 3.050 cannot supersede the Constitution, and that such control creates a monopolistic tyranny lacking oversight by the people. Number 2. Statement of facts. The Oregon Constitution, Article 7 amended, establishes a judiciary with judges elected by the people, Section 1. Oregon Revised Statutes, ORS 2.020, 2.540, and 3.050 require that the Supreme Court, Court of Appeals, and the Circuit Court judges are all to be licensed attorneys, a condition met only through OSB membership, ORS 9.080. The OSB is a private entity created by statute in 1935 that regulates bar licensure under Supreme Court oversight. The Supreme Court itself is composed of bar members. No provision in Article 7 delegates judicial control to the OSB, yet all judges must be bar members, excluding all non-members from judicial eligibility. Number 3. Legal argument. A. No constitutional provisions authorizes bar control. The Oregon Constitution vests judicial power in courts created by the people, Article 7, Section 1. It is silent on bar membership. The Federalist Papers, number 78, Hamilton, affirm that judicial power derives from the people via constitutional design, not private associations. Number 51, Madison, insists on separation of powers, rejecting monopolies over the branches. It is to be noted that no organic state constitution, including Oregon, grants a private bar association judicial authority. Statutory impositions are therefore extra-constitutional. Additionally, If there was a state constitution that allowed for the bar to have control of the judiciary, it would then be in conflict with the federal national constitution and therefore void ab initio. The bar control of the judicial branch is a secret society overreach, absent constitutional sanctions. It is implied in the Constitution of Oregon that judicial powers belong to the people. It is the people that created the Constitution, not private entities. Therefore, no private entity can have claim over the judicial branch, even by statute. Oregon's Article 7 lacks any delegation to the OSB regarding bar control, unconstitutional. Let me restate that, rendering bar control unconstitutional. B. Statutory mandates cannot supersede the Constitution. ORS 2.020, 2.540, and 3.050 mandates bar membership via licensure, but federal number 78 holds that laws repugnant to the Constitution are void. This is also stated in Marbury versus Madison. Statutes cannot override constitutional silence. Such statutes are therefore color of law, lacking root in Oregon's Article 7. The Anti-Federalist Papers, number 11, Brutus, warns legislative overreach creates aristocratic rule. Oregon's statutory bar requirements exceeds legislative power by ceding control to a private entity. This reinforces that constitutional supremacy, federal and state, trumps statutory innovation. ORS cannot lawfully impose bar control absent constitutional amendment by the people. C. Bar control creates a private monopoly and tyranny. Requiring all judges to be OSB members establishes a monopoly that ultimately ties the bar to private British origins, not public will. The bar is a tyrannical secret society dominion intentionally subverting public courts. Anti-Federalist paper number 11 warns of an aristocracy judiciary detached from the people. Oregon's bar exclusively mirrors this warning, limiting judicial candidates to a private group. Elections, Article 7, Section 1, offer oversight, but only within bar-approved pools. There is a loss of public integrity. This transforms courts into private bar courts, structurally public, functionally private, lacking true people's oversight as the OSB gates access to the courts. Number 4, conclusion. All Oregon courts under bar control are unconstitutional private bar courts. The Oregon Constitution, Article 7, vests judicial power in the people, not the OSB. Statutory mandates, or S's, cannot supersede this, as per Federalist number 78. The bar monopoly, per Anti-Federalist number 11 and other lawful sources, acts as a judicial tyranny by excluding non-members and reducing public oversight to a controlled choice. I am a researcher at law and hereby attest to and give testimony of this brief as of 8th of April 2025. I testify under the witness of Yahuwah, the Elohim Most High, as to the truth of all that I say herein under the penalty of lying. Submitted by Gary Dean of the House of Darby, dated April 8th, 2025.
Anthony Devine. We are our sheriffs. Our Article 3, Amendment 7, Civilian Court of Law, Court of Record has made numerous visits and relentless communications to our county sheriffs on Oregon. Why? Because our sheriffs are our first protection against governance overreach. It is our county sheriffs that should be there to assist seniors to prevent their eviction from their home and all they possess. It should be our county sheriffs who protect and defend the people from a corrupt court system. Rather than ticketing them or supporting the illegitimate amended Article 7 courts, our sheriffs seem to be avoiding any engagement with us. The people reaching out for a conversation about their refusal to see us. Contact requests are met with cricket sounds. We are our sheriffs. It is significant that they take a proper oath to the Constitution circa 1859 with its original jurisdiction, that is, to the people rather than to a corporation, to our Creator that is with God included. Such a declaration and oath is needed for there to be remedy in our system of governance. Let's get this ball rolling. It just takes one of you to make it different, to get it started, to assist in awakening your colleagues in sheriffdom. Let it be so. I yield.
Hello, my name's Ron Vroom, and I'm the old white man talking head for the Oregon Statewide Jural Assembly. I'm talking about sheriffs and paradox. Paradox. What we have and should not have, and what we don't have and should have. In Oregon's Constitution, we have Article 7 amended, which we should not have, but that's what the judiciary and the sheriffs enforce upon people that are not in that jurisdiction. Article 7 amended. Bogus since November 8th, 1910. That we should not have. What we should have is original jurisdiction, how it is actually supposed to be, not how the attorneys want it, but how the people, without consideration of how the attorneys wanted it written up in their Constitution. Article 7, original. That's common law. That's what we have. So then we look at de jure, de jure, and de facto. De facto is what we have and should not have, and it's defined in Black's law. De jure is also defined in Black's law, and that's what we should have and do not have, which is original jurisdiction, common law, a civilian common law, court of record, not beholden to military or state or county, but common law of the people. A court is formed, 3 tribunals and a clerk. It's still a court if there's just 3 tribunals, but it's no longer a court of record. So then, de facto and de jure. De meaning of in Spanish, like when you're speaking Spanish, they interchange del and d, del being from and d being of, and del vecchio, or of the old, or from the old. So de facto means of a fact, de jure means of the truth, or of constitutional, but neither one appear in Bouvier, and I thought, how strange. And then I looked up the words, facto and jure, or Jure. And both of those definitions are there without the DE. So I'm not sure when the Bar Association gained control of the dictionaries and started putting the definitions they wanted in, but it happened because we have, and it's so nice to have it in my hand instead of having to look it up on the internet all the time. We have the actual dictionary. We know what the words mean. There's no confusion. And all that the Bar Association, the Oregon State Bar, did you know that I called one day and talked to them over there, and when they make a new member into the Oregon State Bar, the new member has a choice. You could be a JD or you could be an Esquire. I thought, how convenient. The Oregon State Bar can confer a title of nobility on a new member. To confer a title of nobility, don't you have to have authorization from somebody that has the authority to confer a title of nobility? Sounds like the British Accreditation Registry to me, but I don't know. I'm not in that club. But when we're looking at what's going on, the paradoxes are just astounding. Everywhere we look. And when Mike said the other day, it's really hard when everything you thought you knew turns out to be a lie. Yeah, it really is. I remember clearly they had me fooled until I was 75. Just wouldn't admit. Cognitive dissonance. Couldn't see it. But once you see it, you can't unsee it. You cannot unring the bell. And every sheriff has seen it on Oregon. There is no option for denial. I yield.
Hi, this is Eric Dover from the Oregon Statewide Jural Assembly, and this is an open letter to the sheriffs on Oregon. Sheriffs one and all, the ball is in your court. We kicked it into your jurisdiction, which is separate from ours. Alas, it really is one team, you and us. It is, or rather should be, one jurisdiction. Your training, probably from childhood, has been to join the realm of the corporate jurisdiction, which is the entity that pays you to do what you do. You can join our team, that of the people, with a simple turn of a mind switch. A tool to assist in this process is to consider taking a proper oath to the proper constitution with its original jurisdiction and with the laws of nature and of nature's God, as stated in our unanimous declaration of the 13 United States of America. The last several months we have posted and made publicly available what we consider a proper oath for the persons in our governance. Sheriffs are our first effort at insisting on a proper oath, whereas the sheriffs who are in their county position to protect and defend the people from ticketing or sending people to the illegitimate amended Article 7 courts that should not be, from governance, overreach, and taxation that takes seniors' equity, their forever home, and all they possess by enforcing convictions. It's like a shift in the mind. It is the recognition of one's allegiance to the life and that which is God-given. Rather than criminalizing living God-made beings for a dead corporate entity, our sheriffs are our first protection against governance overreach. Taking a solemn oath is needed for there to be remedy in our authoritative system of governance. Once a sheriff cognizes the importance of the proper oath, they can see themselves as one with the people rather than a corporate entity meant to enforce our compliance to the bidding of the state. Therein is offered greater freedom, cooperation, and peace in all our dealings. Let it be
Well,
so.
sheriffs, we greet you with all the best of every good fortune for the good. In all the oaths from sheriffs that we have seen, from Pat Garrett, now retired, to Sam Elliott, they all mention constitutions that attorneys, judges, and others have decided is the definition of constitutional. The Bouvier Law Dictionary, 6th edition, 2nd volume, written in 1856, was, has been, is now, and will continue to define the United States of America's Constitution and Oregon's Constitution at inception in February 1859. That is, original jurisdiction on Oregon, hung out here on the Pacific coast. No law, statute, rule, regulation, ordinance, order, or other may, shall infringe upon our two constitutions. We have the definitive, authentic Jural Dictionary, just 3 years old when Oregon became a state, an independent nation, and the 33rd in the Perpetual Union, a confederation since 1777. The Bouvier Dictionary, 1856, is available on Amazon, is printed in Troutdale, Oregon, of all things, and can be delivered in 3 days at a fair price. Each of you addressed here has an oath to two constitutions that you need to read and listen to with others in a group. The ones who are taking the same oath with the definitions on the table. You are no longer deceived. Now you know. You are responsible for taking the correct oath to the correct constitutions with the laws of nature and of nature's God included. It deals with people and trade and private. In the last 150 years, more or less, it has become corporate and maritime, admiralty, taxes, probate, international, commercial, inter- and intrastate public commerce. Without the office of sheriff properly occupied, there is no constitutional Republican form of government on Oregon. There is the de facto Salem oligarchy, where Kate and Tina are both convicted of breaking their oaths, where 89 legislators broke their oaths on January 21st, 2021, and were convicted. The Article 7 amended judiciary acquiesced to having no proper oath, proof of bondability, and proved themselves unfit for a position of trust, November 2022. Not one rebuttal in 6.75 years, signed, sealed, stamped, witnessed, proof of service published on our website, https://www.orsja.org, and other such places, all documented as facts filed into our civilian common law court of record. Courts decide law and juries decide facts. Judges decide matters of less than $20 in our Article 3, 1 Supreme Court, claiming original jurisdiction found in the Amendment 7 Civilian Common Law Court of Record. There is a lie about which judge, in what court, under what circumstances, and that you should consult an Oregon State bar attorney. Just kidding. You are required to be thoroughly aware and competent in your own oath, knowledgeable to your own responsibilities and obligations. An oath to a constitution that has no regard for the people is, to the people, worse than no oath at all. If one plays ignorant to our true history, there is no service at all. Anything less than a proper oath, with the proper understanding behind it, is just kicking the can downhill on a long road to nowhere good. And I thank you.
Good afternoon. This is Dr. David. I'm here to present a document to the sheriff. Where are our sheriffs? Our Article 3, Amendment 7, Civilian Common Law Court of Record has made numerous visits and relentless communications to our county sheriffs on Oregon. Why? Because our sheriffs are our first protection against governance overreach. It is our county sheriffs that should be there to assist seniors, to prevent their eviction from their home and all they possess. It should be our county sheriffs who protect and defend the people from a corrupt system rather than ticketing them or supporting the illegitimate amended Article 7 courts. Our sheriffs seem to be avoiding any engagement with us, the people, reaching out for a conversation about their refusal to see us. Contact requests are met with cricket sounds. Where are our sheriffs? It is significant that they take a proper oath to the Constitution, circa 1859, with its original jurisdiction. That is, to the people, rather than to a corporation, to our Creator, that is, with God included. Such a dejuration, an oath, is needed for there to be a remedy in our system of governance. Let's get this ball rolling. It just takes one of you to make a difference, to get it started, to assist in awakening your colleagues in sheriffdom. Let it be so. Thank you.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying, and then he jumps out of the car, and he's got both his hands up.
And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, to shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.